We've already talked about where you should store your estate planning documents. The real question is, are there people who you should distribute the documents to? And in some cases, the answer is absolutely. My name's Gregory Singleton. I'm an estate planning and probate attorney located in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. Just a reminder, if you like what you see in today's video, please feel free to like and subscribe below. It sure helps to support the channel. So who should receive copies of parts of your estate plan? Well, it depends on the type of document. Now we're going to talk about the 5 key documents here: the will, the trust, the healthcare directive, durable power of attorney, and the guardianship directives. So let's just start with the will. Who needs to have a copy of the will? Really, nobody needs to have a copy of the will except for you. You need to have a copy of the original. You probably should tell people where they can get a copy of the will, but nobody actually needs to have a copy of the will other than you. Some people do choose to give a copy out to their beneficiaries or to their personal representatives, and that's fine. Sometimes that can lead to more harmony in the family, or maybe it's just easier, but realistically, nobody but you needs to have a copy. For the revocable living trust, the answer is pretty much the same. Nobody needs to have a copy except for you, with the exception of if you have a co-trustee for your revocable living trust, then the co-trustee will need to have a copy of the revocable living trust document. After you die, the successor trustees will take over and they'll get a copy at that point, but until that point, they don't need a copy, nor do the beneficiaries. Your healthcare directive is a little bit different. You're going to want to spread this kind of far and wide. Anyone who's a healthcare agent needs to have a copy. Now, notably, it's okay to have a copy of your healthcare directive. You don't tend to need an original of the healthcare directive for it to be effective. So make sure to have a copy given to any of your healthcare agents. You can also take a copy and give it to your primary care physician or the hospital down the road where you're likely going to go if you get in trouble. They can put it on file. Now, not all hospitals and clinics will do that, but it doesn't hurt to ask. Durable power of attorney. This is the opposite of the healthcare directive. You probably don't want to give away your copies of your general power of attorney. This is giving someone access to all your financial means, which would be your bank accounts, your investment accounts, your real estate, etc. So you probably want to keep this close to the vest. Especially if it is an immediate power of attorney, meaning that it is effective as soon as it was executed and the authority vests in the attorney in fact as soon as you put pen to paper and sign it. Now, if it's a springing power of attorney, meaning it's only effective when you become incapacitated or upon some other event, then you could distribute it to your various powers of attorney and they won't be able to use it until that event happens. But generally, just to be safe, I tend to advise clients just to keep that close to the vest and keep it with your other estate planning documents. Guardianship directive. This is kind of like the healthcare directive. You want to distribute it to anyone that's a guardianship designee because they need to be able to use it to have proof to take care of your kids right away if something happens. And they only have 60 days in which to file it with the court when something happens to you. So you don't want to take any time out of that for them that they may need to be searching around for your guardianship directive. You should probably also tell other people about the guardianship designations, such as your neighbors and any family members. You need to give a copy, or you should give a copy also to the school, or at least notify them of who the guardianship designees are in case something happens to you, because schools are pretty tight about who can pick up kids and who can have interaction with kids on school grounds. Two tricks that you might want to do is first is get a small laminated card and put it in your wallet and have it say who has a copy or who can be contacted for a copy of your estate planning documents. That way if something happens to you, then the hospital can go through your wallet and find out where to give stuff out. Secondly, in your healthcare directive, you can put in there that you have various estate planning documents, and person A, B, and C can be contacted for copies of the estate planning documents. That's another way that people can be put in touch with the right individuals for who has the right documents for you. That's it. It's a real quick video today of who should be given copies of your estate plan. I hope you liked today's video. If you did, please feel free to like and subscribe below. If you have any questions, go ahead and ask them in the comments and I'll try to get to them. Otherwise, until next time, this is Gregory Singleton with Signature Law.